welcome to The Blitz. Dear viewers, I'm your host today. A few days back, the three bills gets its nod by the President Draupadi Murmu on 21st and 22 December. Which are these three bills? These are the three old laws. It is said that a country is run by the constitution or the legal document. Here is the report that I have about these laws. It is IPC 1860, which is converted into, or we can say, upgraded version made by the ruling party BJP. It is known as Bharatiya Nyaya Samhita. A criminal law turns into Nyaya Samhita. 2023. The old one, procedural law, which is known as CRPC, Code of Criminal Procedure 1973, now turns into Bharatiya Nagarik Suraksha, second revised edition 2023, and another one which is popularly known as Indian Evidence Act 1872, Indian Evidence Act, now known as Bharatiya Saksh, second revised edition 2023. These three laws now converted into upgraded version 2023. So here are reports that I have about these laws, who introduced it, how it gets presidential nod, and what are the hurdles and developments made therein. So the very first question arises in our mind as a citizen of India, that who introduces these bills? It was none else but the Central Home Minister, Mr. Amit Shah, who introduced these three criminal bills in the lower house. After getting it passed from the lower house, it went back to the upper house, the Rajya Sabha. After getting passed from there, finally it comes to the president and gets final nod on the very day 20 and 21st December. The first version of the said bill was facing a huge criticism on its being vague on different topics, definitions and version, you can say. Seeing the hurdles, the ruling party sent it back to the 31 member standing committee, which was led by BJP MP Brijlal, and the committee submitted its report on 7th November, pointing several corrections which was later on criticized by opposition MPs. Despite that fact, the bill gets assent from both the houses and finally goes to the president. Now let's see what are the major changes made therein. When we talk about the major changes, it is said, Vice President of India said that this version of criminal laws are a final and furnished version of replacing the old one. what are the corrections made therein is grammatical and language error, which is omitted through the second reading, you can say. Explains sedition, crime, unlawful activities prevention act, especially talking about section 15 and IPC section 113. These are the major aspects which are talked as the central point in criminal law. Despite that, there are a few changes made in section 18A and section 18B of UPA law. Changes also made in the definition of terror or terrorist act is clearly defined in the new version of these criminal laws. It differs from that of UPA's earlier definitions. Terrorist act and the punishment prescribed in IPC section 53. We witness death penalty and life imprisonment for the terrorist act. This is the another change which is made in the existing law. And for mob lynching, capital punishment is prescribed in new law, which was not present there in earlier laws. So these two things obviously reflect a kind of development and amendment in the Indian legal system. Let's have a look on the repealed provisions. It is sedition law, criminalization of homosexuality, especially section 377, witnesses change, repealed, and the third one is adultery. So these three laws are no more in Indian history with the passing of the current existing law. Now let's talk about the cruelty, danger to life, health, or any other kind of danger if any person causes to anyone, shall be held liable and also be punished with the imprisonment of 3 years. Now talking about the CRPC and few changes therein, the police should consult a victim before withdrawing a case punishable by 7 years or more. This is the key point I found out, which shows a sign of change in policing and unauthorized publication of court proceedings, especially in the matter of rape, victim and sexual assault. If any person found guilty of publishing court proceeding, especially relating to these two cases, shall be held liable of this crime which is prescribed in the new law without prior consulting or the permission of the court. If he has no permission, he is not liable to publish these two proceedings. If someone does that, he shall be held guilty and be sent to jail for at least 2 years just for that crime. Now I move ahead. Here is the central and key point of the news I got from the Hindu. The credit goes to the Hindu, especially talking about section 113 of the revised bill has modified the definition of the crime of terrorism to entirely adopt the existing definition under section 15 of the Unlawful Activities Prevention Act 1967. UPA. The UPA often labeled as draconian the UPA, often labeled as draconian, defines as a terrorist act any act with intent to threaten or likely to threaten the unity, integrity, security, economic security and sovereignty of India, or with intent to strike terror or likely to strike terror in the place or any section of the people in India or in a foreign country. The original bill, mob lynching and hate crime, a separate category of murder for the first time. So, the mob lynching has a kind of separate recognition with the advent of new crime rules. The offense deals with the case where murder is committed by 5 or more persons. It is a notable point. If such kind of crime committed by 5 or more persons, they shall be held guilty of mob lynching, for which now the estimation of special category of crime and punishment is the capital punishment, which shall also be like imprisonment for life. Now, the offense deals with cases where murder is committed by 5 or more persons acting in concert with one another on grounds of race, caste, or personal belief, community, sex, place of birth, or any of these. They shall be held guilty. However, it is criticized by the panel for prescribing a lesser minimum sentence of imprisonment of 7 years as opposed to the offense of murder, where the minimum sentence is imprisonment for life. Taking the critique into consideration, the revised bill, it was earlier gone through the first reading, but with the assent second reading after the committee's report on 7th of December, when it got passed by the 2 houses and finally gets note of the president. Now the change made in specifically this case is taking the critique into consideration. The revised bill has removed the minimum punishment of 7 years and now penalizes mob lynching at par with murder. So now the punishment for the murder equals to the mob lynching, for which there is punishment prescribed out of 6 punishments in section 53. Earlier it was murder or life imprisonment. So the mob lynchers would be penalized as a separate kind of committing murder. This is all for now. Keep watching the Blitz. I'll always keep you updated with the developments and all kind of updates about the news. Stay updated, give love to my channel, the Blitz, and stay safe. Jai Hind.